She canceled the photographer 48 hours before her wedding and paid dearly. For 11 months, a wedding photographer poured everything she had into building her dream client's perfect day. Then, 48 hours before the ceremony, she got a phone call that destroyed it all. And the reason behind that call would shock everyone in that courtroom. The photographer had been in business for 7 years. She specialized in high-end estate weddings, the kind held on private grounds with string lights and champagne towers and guest lists that read like a charity gala. When a couple contacted her through a luxury wedding directory in early spring, she took the booking immediately. The contract was detailed, the deposit was substantial, and the venue, a sprawling private estate managed by a regional property management company, looked on paper like the perfect backdrop. The property management company oversaw the estate on behalf of its private owners who lived abroad. They had been booking the grounds for weddings, corporate retreats, and private events for nearly a decade. They had a coordinator on staff. They had a standard event agreement. Everything looked legitimate. The photographer signed a separate vendor access agreement with the property management company directly, as required. She paid a $400 vendor access fee. She drove 40 minutes to the estate 3 times over 11 months. Once for an engagement session, once for a site walkthrough, and once to meet the couple's florist. She turned down 4 other bookings on that same date, including one valued at $6,200. Then, 48 hours before the wedding, the property management company called her. The event was canceled. The estate was unavailable. No further explanation was given. The couple scrambled. The wedding eventually happened, scaled down, relocated, and photographed by someone else. The photographer received no kill fee, no compensation, and no acknowledgement that she had lost anything at all. She sued the property management company for $14,800, covering her lost contract fee, the value of the bookings she had declined, and the cost of her 3 unpaid site visits. In court, the photographer's case was methodical and precise. She presented her signed vendor access agreement, her deposit receipt, her declined booking correspondence, and a detailed log of every hour she had spent preparing for this event. Her attorney argued that the property management company had entered into a binding agreement, collected her fee, and then voided her participation without cause and without notice. She testified that she had restructured her entire calendar around this event. Her voice was steady. Her documentation was immaculate. The property management company pushed back hard. Their attorney argued that the vendor access agreement contained a force majeure clause, a standard provision releasing them from liability in the event the property became unavailable due to circumstances beyond their control. They claimed an unforeseen structural issue with the estate's main pavilion had forced the cancellation. They had notified all vendors as quickly as possible. They expressed sympathy but denied liability. It was a reasonable defense. Force majeure clauses exist for a reason. Natural disasters happen. Structural failures happen. The photographer's attorney acknowledged this, but then asked a single quiet question. When exactly was the structural issue discovered? The property management company's coordinator testified it was identified 2 days before the wedding, but the photographer's attorney had subpoenaed the estate's maintenance records. Those records told a different story entirely. The structural assessment of the pavilion had been completed not 2 days before the wedding, but 4 months prior. An engineering report, dated in midsummer, had flagged the pavilion as requiring significant repair before it could safely host events exceeding 100 guests. The wedding had a guest list of 140. The property management company had continued booking the estate for 4 additional months after receiving that report. They had collected fees from the couple, from the caterer, from the florist, and from the photographer. They had said nothing. The force majeure defense evaporated on the spot. This was not an unforeseen circumstance. It was a known liability they had chosen to ignore until they could no longer defer it. The judge ruled in the photographer's favor. The property management company was ordered to pay $14,800 in full, plus $200 in court costs. The judge noted in her ruling that the force majeure clause could not be invoked to shield a party from consequences they had actively concealed. Ignorance is a defense. Concealment is not. The property management company did not appeal. Within 6 months, the estate had been quietly removed from every luxury wedding directory where it had been listed. The couple, who had filed their own separate civil complaint, reached a confidential settlement. The photographer used her award to fund the deposit on a studio space she had been saving for. She still shoots weddings. She now requires a venue certification before signing any vendor agreement. The property management company knew the pavilion was unsafe for 4 months and said nothing. They collected every fee, honored no obligation, and bet that no one would look closely enough to find the report. So here's the question worth sitting with. When a business discovers a problem that will hurt its clients and chooses silence over transparency, at what point does that silence become fraud?